Hi, here at Team Believe It, we believe every question has an answer, every problem has a solution, and everything is possible. Please subscribe to our channel, hit the like button, and share these videos with everyone you know. By the way, we saved the best tip at the end of the video. Now for today's topic, we'll delve into an important, yet often misunderstood financial topic, bankruptcy. Whether you're someone facing financial difficulties, a student, or just curious about how bankruptcy works, this guide will help clarify the complexities of bankruptcy from the basics to the common misconceptions. Chapter 1. What is bankruptcy? Let's start with the basics. Bankruptcy is a legal process designed to help individuals and businesses eliminate or repay debts under the protection of the bankruptcy court. When a person or entity is unable to meet their financial obligations, they can file for bankruptcy as a way to either wipe out their debts or create a plan to pay them back over time. What are the types of bankruptcy? There are several types of bankruptcy, but the most common for individuals and businesses are Chapter 7, Bankruptcy, often referred to as liquidation bankruptcy. In this process, a debtor's non-exempt assets are sold, and the proceeds are used to pay off creditors. Once this process is complete, most remaining debts are discharged, meaning the debtor is no longer legally required to pay them. Chapter 13, Bankruptcy, also known as reorganization bankruptcy. This type allows individuals with a steady income to keep their property and repay creditors over time, typically 3 to 5 years. After the repayment period, remaining debts may be discharged. Chapter 11, Bankruptcy. Primarily used by businesses, this is another form of reorganization bankruptcy. It allows a business to continue operating while restructuring its debts. In some cases, individuals with particularly large debts may also file under Chapter 11. What is the purpose of bankruptcy? The primary goal of bankruptcy is to provide relief to those overwhelmed by debt. It offers a fresh start to individuals and businesses by either discharging debts or providing a manageable repayment plan. Importantly, it also protects creditors by ensuring that available assets are distributed in an orderly and fair manner. Chapter 2, the Bankruptcy Process. Understanding the bankruptcy process is crucial, whether you're considering filing yourself or simply want to know more about how it works. Step 1. Pre-filing requirements. Before filing for bankruptcy, debtors are required to complete credit counseling with an approved agency. This step is mandatory and helps ensure that bankruptcy is the right option. The counseling agency will provide a certificate that must be filed with the bankruptcy petition. Step 2. Filing the petition. The next step involves filing a bankruptcy petition with the court. This includes detailed information about the debtor's financial situation, including income, expenses, debts, assets, and a statement of financial affairs. For Chapter 7, a means test is used to determine eligibility. This test evaluates whether the debtor's income is low enough to qualify for Chapter 7, or if they must file under Chapter 13 instead. Step 3. Automatic stay. Once the bankruptcy petition is filed, an automatic stay goes into effect. This is a powerful tool that immediately stops most creditors from pursuing collection actions against the debtor. It halts foreclosure proceedings, repossessions, wage garnishments, and harassing phone calls from creditors. Step 4. Meeting of creditors. Approximately 20 to 40 days after filing, the debtor is required to attend a meeting of creditors, also known as a 341 meeting. During this meeting, the bankruptcy trustee and creditors may ask questions about the debtor's financial situation and the information provided in the petition. Step 5. The role of the bankruptcy trustee. A bankruptcy trustee is appointed to oversee the case. In Chapter 7, the trustee is responsible for liquidating non-exempt assets and distributing the proceeds to creditors. In Chapter 13, the trustee reviews the proposed repayment plan and ensures that the debtor complies with it. Step 6. Discharge of debts. The ultimate goal of bankruptcy is the discharge of debts. In Chapter 7, this typically occurs within a few months of filing. In Chapter 13, it happens after the repayment plan is completed. A discharge means the debtor is no longer legally required to pay the debts covered by the bankruptcy. Chapter 3. Common misconceptions about bankruptcy. Bankruptcy is surrounded by myths and misconceptions that can lead to unnecessary fear and confusion. Let's clear up some of these common misunderstandings. First, misconception. Filing for bankruptcy means you've failed financially. Bankruptcy is often seen as a sign of personal failure, but this is far from the truth. Many factors can lead to bankruptcy, including medical expenses, job loss, divorce, or economic downturns. Bankruptcy is a tool to help individuals and businesses regain control of their financial situation, not a mark of failure. Second, misconception. Bankruptcy will ruin your credit forever. While bankruptcy does impact your credit score, it doesn't mean you'll never have good credit again. In fact, many people find that their credit score begins to improve shortly after bankruptcy, especially if they manage their finances wisely post-bankruptcy. Third misconception, you'll lose everything if you file for bankruptcy. This is a common fear, especially with Chapter 7 bankruptcy. However, bankruptcy laws provide exemptions that allow you to keep essential assets, such as your home, car, retirement accounts, and personal belongings. The specifics vary by state, but the idea that you'll lose everything is largely a myth. Fourth misconception, all debts are wiped out in bankruptcy. Not all debts can be discharged in bankruptcy. Common exceptions include student loans, child support, alimony, certain tax debts, and debts incurred through fraud. It's important to understand which debts will and won't be discharged before filing. Fifth misconception, you can only file for bankruptcy once. You can file for bankruptcy more than once, but there are time limits between filings. For example, after a Chapter 7 discharge, you must wait 8 years before filing for Chapter 7 again. However, you may be able to file for Chapter 13 sooner, depending on the circumstances. Chapter 4. Life after bankruptcy. Life after bankruptcy can feel daunting, but it's also a time for a fresh start. Here's how to move forward. First, rebuilding credit. The first step after bankruptcy is to rebuild your credit. This can be done by obtaining a secured credit card, making timely payments, and keeping balances low. Over time, these actions will help improve your credit score. Second, financial planning. Budgeting and financial planning are crucial post-bankruptcy. This includes tracking your income and expenses, saving for emergencies, and avoiding unnecessary debt. Consider working with a financial advisor to create a plan that fits your needs. Third, avoiding future financial pitfalls. Bankruptcy can be a learning experience. Take this opportunity to reflect on what led to your financial difficulties and how to avoid similar issues in the future. This might involve building an emergency fund, diversifying your income sources, or improving your financial literacy. Conclusion: empowering financial decisions. Bankruptcy is a significant financial decision, but it's also a powerful tool that can help individuals and businesses overcome financial difficulties. By understanding the process, dispelling misconceptions, and planning for the future, you can navigate bankruptcy with confidence and make informed financial decisions. As always, here at Team Believe It, we believe every question has an answer, every problem has a solution, and everything is possible. Please subscribe to our channel, hit the like button, and share these videos with everyone you know. Thank you.